Good morning, everyone, and welcome back to the AFSA series of webinars, The Cutting Edge, in which we explore important topics in arbitration and in law. This morning's webinar discusses good faith in international arbitration, and it's a great pleasure to be able to say that it is hosted by Pinsent Masons. Pinsent Masons is, of course, a world-ranking international law firm which employs a legal team of some 1,800 people with its headquarters in London, but with a presence around the world, and I'm happy to say, in Johannesburg as well. And Pinsent Masons, of course, are founding members of AFSA. Participating in our talk today are Claire Bigelow-Nuttall, a partner in the risk advisory services of Pinsent Masons, and she is joined by Mohammed Somray and Andrew Fawcett, both of whom, I'm happy to say, are located at Pinsent Masons Johannesburg as senior associates. Before asking Andrew to take over, I can't resist a mention of an extraordinary English judgment which attempted more than 100 years ago to explain what good faith means. And you'll judge for yourself whether the definition given is so clear and so helpful as to make today's discussion unnecessary. Well, said the Chancery Court in 1892, now, what does good faith mean? What is meant by those two English words? So the judges could still count. I think the best way of defining the expression, so far as it is necessary or safe to define it, is by saying it is the absence of bad faith. Well, ladies and gentlemen, if that's enough to tell you what good faith is, you needn't listen. But I would suspect that we will gain a lot more from listening to this webinar. Andrew, if you're ready.
Thank you, Michael, and good morning, everyone. Thank you for joining us this morning. In this AFSA international webinar, where we'll be discussing the principles of good faith insofar as they may arise in international arbitrations. We'll be discussing how the concept of good faith is approached in various jurisdictions around the globe, as well as some practical considerations that the parties should consider when commencing international arbitrations. Before getting stuck into the discussion, let me introduce you to the panel that will be presenting to you today. My name is Andrew Fawcett, and as Michael mentioned, I'm a senior associate based in the Johannesburg Pinsent Masons office, specializing in dispute resolution within the energy and infrastructure sectors. I'm joined this morning by my colleagues, Claire Bigelow-Nuttall. As Michael mentioned, she's a partner based out of our London office, although she is currently joining us from Amsterdam this morning. Claire specializes in international investment and commercial arbitration and has experience across common and civil law jurisdictions. And finally, Mohammed Somray, senior associate in our Johannesburg office. He is a specialist construction and engineering lawyer with experience in both front-end construction and dispute resolution. So that is the panel who will be discussing good faith with you today. Just on an administrative level, please feel free to drop any questions you may have into the chat function, and we will try our best at the end of the discussion to answer some of these questions. But if we don't get to them today, we will drop you a mail after this, so far as we're able to. So, Claire, to kick things off, I'm not sure Michael's definition of good faith was as clear as some of us would have liked. So what is good faith? And speaking from an English common law perspective, does it apply within the context of international arbitrations?
Well, thank you very much for that, Andrew. And thank you also, Michael and AFSA, for the opportunity to speak this morning. It's a real pleasure. Yes, Michael's definition, or indeed rather the Chancery Court's definition, possibly of limited utility. But the question of what is good faith has obviously been discussed a lot. And the answer to that question will have a different answer depending on where you're based. And so starting with England and a common law perspective is possibly as good a starting point as any, because it's somewhat of an outlier amongst some of the jurisdictions that we'll look at and discuss today. And that's because, as many of you may already know, the common law doesn't generally recognize the concept of good faith, and certainly not in a codified way that some of the other jurisdictions that we'll be looking at today do. And as to what good faith means in a common law context, I think possibly the 1989 House of Lords case of Interfoto and Stiletto somewhat more helpful. Possibly not, you might disagree, but Lord Bingham there described good faith as playing fair, coming clean, putting one's cards face upwards on the table. And over the years, other definitions of the concept of good faith have been articulated as follows: honesty in the performance and loyalty to the party's bargain, acting within the spirit of an agreement, acting consistently with the justified expectations of the parties, and faithfulness to an agreed common purpose. So all of those a bit more of a positive definition than the absence of bad faith, something perhaps a bit more to work with. And so despite having a reasonably good idea of what the principle of good faith means, the English courts have nevertheless historically been reluctant to recognize the existence of a concrete good faith doctrine. And in quite strong language, in a somewhat older case, Walford and Miles, Lord Ackner considered good faith to be inherently repugnant to the adversarial position of the parties when involved in negotiations. And again, in the Interfoto and Stiletto case that I just mentioned, Lord Bingham explained in somewhat more tempered language that rather than committing itself to an overriding principle of good faith, English law preferred to develop piecemeal solutions in response to demonstrated problems of unfairness. And this reticence to acknowledge good faith as an applicable principle in commercial contracts under English law has historically been based on the following rationale. First, as seen from the Interfoto case, the preferred method of the English courts is to find piecemeal solutions rather than to enforce broad overarching principles. Secondly, under English law, parties are generally free to negotiate terms and pursue their own self-interest without fear of interference from the courts. And thirdly, the English courts believe that a general requirement of good faith could undermine the principle of contractual certainty, which, as we know, is so important to the parties. And often where an implied duty of good faith has been found in commercial contracts under English law, this has been through the application of an objective test. And that objective test was well articulated in the case of Mid-Essex Hospital Services, in which the courts described that test as, when given the wording of the contract and the general context, would the conduct of the parties be regarded as commercially unacceptable by reasonable and honest people? Now, applying this objective test in the Yam Seng case more recently in 2013, the English court recognized a limited form of good faith as an implied contract term. Now, that case related to a written contract that was entered into by the parties under which the defendant authorized the claimant to explore selling certain fragrances in the duty-free markets of the Middle East, Asia, Africa, and Australia. And a disagreement arose between the parties, and amongst other complaints, the claimant argued that the defendant had breached an implied term to perform the contract in good faith. In analyzing the agreed terms of the contract, the judge considered that the defendants had misled the claimants in breach of an implied duty of honesty and had also breached an implied term to perform the contract in good faith. So there was an implied term of good faith, and the reasoning that allowed the judge to reach that decision was that in contracts that the judge termed relational contracts, there might be an extra standard of protection, in the judge's words, a higher degree of communication, cooperation, and predictable performance based on mutual trust and confidence. So if we look at this principle of good faith that the English courts have been so keen to avoid formalizing, what we in fact see is the courts have been more and more frequently finding ways to imply a duty of good faith into certain types of commercial contracts and relationships, and in particular into these so-called relational contracts. The implied duty of good faith has in some cases been a way for the courts to balance the certainty and predictability on the one hand with the fulfillment of parties' reasonable commercial expectations on the other. And in thinking about what constitutes a relational contract, the court was referring to contracts involving longer term relationships, such as, for example, long-term distribution, franchise, joint venture, or construction contracts, contracts which tend to have or require a high degree of cooperation and an expectation of loyalty and a common goal. So in summary, what we have in the common law under English law is a starting position of no fixed principle of good faith, but a willingness of the courts to imply a duty in certain circumstances, for example, that of relational contracts. So that's a very quick run through the English law position, and starting primarily there to provide contrast to how good faith might be looked at more broadly in other jurisdictions, which I gather we'll hear more about from Mo now.
Thanks, Claire. Very useful to get that base point from the English law perspective. Mohammed, from the South African perspective, South Africa has its roots in, as we know, Roman Dutch law as influenced by common law, but it's also a constitutional democracy, with the constitution being the supreme law. The constitution incorporates African principles such as Ubuntu. And with this in mind, what is the South African position within the concept of good faith?
Thanks, Andrew, and thanks to everybody joining us today, and to AFSA for hosting us as well. South Africa has an uncodified legal system, and that means there are multiple sources of law rather than one primary source or code where the whole law can be found. South Africa follows the common law tradition, and the law consists of the Constitution, which is the supreme law of the land, as you've mentioned, legislation, judicial precedent, the common law, and customary law. Insofar as the concept of good faith is concerned, unlike civil law jurisdictions, and as Claire has mentioned, common law jurisdictions do not have an implied obligation of good faith. If parties want good faith to apply to their transactions in common law jurisdictions, such as South Africa, then it would be prudent for them to incorporate a specific provision within their contracts. Put differently, good faith is not a self-standing principle, as is the case in civil law jurisdictions. Having said that, good faith as an underlying principle has traditionally acted as an element of fairness in South African law. Public policy in the South African context is informed by values enshrined in the Constitution, which is comprised of fairness, reasonableness, good faith, and Ubuntu. If we look at the South African case law from an analysis of it, the position is a bit unclear though, as there's some tension between the highest courts and the application of legal certainty on the one hand versus good faith on the other. And this is an important point to note as an arbitration practitioner. And the reason I say that is it will probably inform the manner in which an argument of good faith will be assessed by an arbitrator or a tribunal. So if we look at the cases, on the one hand, the Supreme Court of Appeal in Brisley versus Drotsky provided that good faith is an underlying obligation which supplements established rules such as pacta sunt servanda. This indicates that good faith is not an actionable concept in isolation. Although Brisley was before the enactment of the Constitution, this trend has continued in South Africa's penultimate court, and there are a number of cases reiterating that principle. As an example, in PricewaterhouseCoopers versus National Potato Cooperative, the SCA held that principles such as good faith should only curtail the certainty of contracts in manifest instances. The court made it clear that it is an important consideration that there be certainty of agreement. If we look at the constitutional court cases, on the other hand, there seems to have been a broader approach adopted to good faith. For instance, if we look at Barkhuizen versus Napier, which was the first case to indicate a change of course, providing that the Constitution is respectful of certainty of contract, but that public policy would be determined in accordance with the Constitution. The Constitutional Court in that matter held that this approach leaves enough space for pacta sunt servanda to apply, but it still allows constitutional values to be enshrined. The case centered around a time barring provision in an insurance contract, and it was alleged that the time barring clause was unconstitutional. In finding that the provision did not prevent the claimant from a fair and adequate opportunity, the court did, however, mention that public policy cannot be separated from fairness and basic elements of justice. The Constitutional Court then in Everfresh Market Virginia versus ShopRite Checkers went a step further and sought to fuse concepts such as Ubuntu with the law of contract. Essentially, Ubuntu embraces solidarity, humanness, interconnectedness, and mutual respect. The court in Everfresh provided that it emphasizes the commercial nature of society and carries in it the idea of humaneness, social justice, and fairness, and envelops the key values of group solidarity, compassion, respect, human dignity, conformity to basic norms, and collective unity. Going even a step further than that, in Botha versus Rich, good faith was seemingly introduced as a primary right capable of enforcement itself, and on the principle that a court can refuse to give effect to a contract on the basis that its enforcement would be unreasonable and unfair. In that case, the court provided that honoring that contract cannot therefore be a matter of each side pursuing his or her own self-interest without regard to the other party's interests. Good faith is the lens through which we come to understand contracts in that way.
Thanks, Mohammed. Clear the South African and English law positions, both being common law based, seem quite similar, but you have practiced across a number of civil law jurisdictions, but also conducted a number of arbitrations which are subject to or governed by civil law. Is good faith treated differently in these jurisdictions?
Thanks, Andrew. Yes, I have. I've had the pleasure of practicing in France for some years, and I think it's very fair to say that the civil law jurisdictions do take a very different approach, both from English law and from the South African position that Mohammed just told us, and which does sound very similar in many respects to English law. I was really interested to hear. So starting then with France, under French law, the duty to negotiate and to perform a contract in good faith applies automatically. It doesn't need to be expressly included in the contract itself. Parties aren't able to contract out of this duty. It's in the civil code. So very simply put, if French law applies, the duty of good faith will apply to the parties' relationship. Now, I think what's interesting about French law is the question of when this duty of good faith applies. At what stages of the commercial relationship are the parties obliged to act in good faith? Now, we know, of course, that the duty applies at the stage of performing the contract once it's concluded, but a specificity of French law is that the duty of good faith kicks in at an even earlier stage during the pre-contractual negotiations phase before the contract is signed. And this hasn't always been the case in France. And in fact, it was until 2003 a hotly debated question until the landmark judgment in the Manoukian case, in which France's highest court, the Cour de Cassation, found that an abrupt breaking off of relations relating to a sale of shares in a company amounted to a breach of the parties' obligations of good faith. And as a result of this, the plaintiff was entitled to claim the cost of the negotiations and preliminary studies which it had undertaken, fairly significant liabilities. And this principle has since then been codified in the form of Articles 1104 and 1112 of the French Civil Code. Now, contrast that, of course, with the position under English law, which, as you'll remember, I mentioned, has declined to embrace any strict contractual duty of good faith. And in relation specifically to pre-contractual good faith, you'll recall that I mentioned the judgment of Wolford and Miles and the fairly strong language of Lord Ackner in that case, who went so far as to describe the concept of a duty to carry on negotiations in good faith as inherently repugnant to the adversarial position of the parties when involved in negotiations. So quite starkly different positions. In France, good faith, all for it. Stick it in the code, it's great. England, inherently repugnant. But quickly looking at how the duty of good faith itself constitutes itself under French law, this can generally be broken down in the following ways. First, through a duty of loyalty that requires parties to provide pertinent information and to not act in a way which might be prejudicial to the other party's interests. Second, through a duty of collaboration, which requires parties to refrain from acting in a way which would render the performance of the contract more difficult or even impossible for the other party. And thirdly, through a wide-ranging duty to advise. Now, for example, in a construction context, which is an area that Andrew and Mo and I do a lot of work in, contractors are expected under French law to advise the employer regarding, for instance, the risks relating to soil conditions, the cost of carrying out the works, the inadequacies of planned works in light of any particularities at the site, the adequacy or inadequacy of a chosen material, the usefulness of the works, and the applicable regulations. And in the event that a contractor fails to do so to provide that advice, they could find themselves liable for any resulting damages. So not a duty to be taken lightly. So what about some other civil law jurisdictions like the UAE or Spain? Well, good faith is also a well-recognized principle in the MENA region. And there it governs all aspects of contractual relationships, starting from the negotiation phase through to the execution of contracts, their performance, and even their termination. In the UAE, it's Article 246 of the Civil Code, which expressly refers to the contract being performed in accordance with its content and in a manner consistent with the requirements of good faith. And those requirements are further set out by reference not only to law, but under South African law, as we heard from Mohammed, also by reference to custom and by reference to the nature of contracts, for example, commercial or construction-related contracts. And there's further language in the UAE Civil Code about the mandatory nature of that obligation. So turning to consider what this actually means in practice, as mentioned, like under French law, there's a pre-contractual duty of good faith. And again, similar to French law, this duty encompasses both an obligation to transparently disclose any matter or event that may impact or influence the performance of the contract, and also a duty to avert any act or omission that might adversely impact performance. So now what about Spain? Now, I haven't counted them myself personally, but I understand that there are no fewer than 55 references to good faith in the Spanish Civil Code. So it's fair to say that it's a principle that also has a very important place in the Spanish legal system. And while many of the references that I mentioned in the Civil Code arise in the context of, say, family law or real estate, there are also some very general references that apply to all commercial contracts and the exercise of commercial rights. And good faith in the performance of these commercial contracts is in particular enshrined in Articles 7 and 1258 of the Spanish Civil Code. Now, similar to French and UAE law, some of the duties imposed on parties under Spanish law include providing information, confidentiality, and loyalty. And this extends also to a duty not to withdraw from contractual negotiations without just cause when it was reasonable for the other party to expect the conclusion and the signature of an agreement. However, unlike French or UAE law, the pre-contractual duty of good faith hasn't been codified expressly. It's nevertheless been successfully inferred from other parts of the Spanish Civil Code. And conscious that I'm obviously not a qualified civil lawyer, I will limit myself to those remarks on civil law for the moment, as there may well be participants in our webinar and attendees who are better versed in those legal systems. But I will pass back over to Mohammed to tell us a bit more about some other approaches.
Thanks. I think from what we've discussed already is that there seems to be quite a polar disparity between how good faith is approached in common law jurisdictions and in civil law jurisdictions. Mohammed, in light of these differing approaches to good faith, are there any practical considerations that practitioners should bear in mind when conducting international arbitrations, especially, for example, international arbitrations seated in South Africa?
Absolutely, Andrew. I think there are. Firstly, from a procedural standpoint, arbitrating parties must consider the arbitration agreement and the applicable rules, and whether and to what extent it incorporates the standard of good faith. If required, amendments should be made to either introduce good faith or to clarify its application where it's already included. If we look at more substantive aspects, I'd like to maybe just deal with a recent case from the Supreme Court of Appeal in the matter between Capitec Bank Holdings Limited and another versus Coral Lagoon Investments and others. The case centered around consent as a requirement for the sale of shares and whether a standard of good faith required the granting thereof. I think the case provides some useful commentary on what falls within the ambit of good faith and what can and cannot be achieved with reliance on the standard. In that case, the SCA found that the subscription agreement did not require that Capitec must consent to the sale of shares. The court pointed out that ordinarily that would suffice as a basis to conclude that the order of the High Court could not stand. However, it was necessary to address the fact that the High Court had reasoned that Capitec was in breach of its contractual as well as its common law duty of good faith to Coral Lagoon, which led the High Court to impose upon Capitec an order to provide the consent, which in the view of the High Court, it had impermissibly withheld. It was mentioned by the Supreme Court of Appeal that the Constitutional Court has spoken decisively in Bedica and others versus Trustees, Oregon Trust and others, as to how good faith figures in our law of contract. More particularly, Bedica affirms, amongst other things, the following principles. Firstly, the fact that contracts freely and voluntarily entered into must be honored remains central to the law of contract. Also, while good faith underlies the law of contract and informs its substantive rules, good faith and fairness are not substantive freestanding principles to which direct recourse may be had so as to interfere with contractual bargains or decline to enforce contracts. The SEA also pointed out that the law of contract is part of our common law, and good faith is one of a number of principles that inform the substantive rules that make up the law of contract. Having said that, good faith is not a duty that may be imposed upon a party as a matter of law of contract, so as to determine the terms upon which the parties to a contract will be taken to have agreed. The court recognized that a showing of good faith between contracting parties is a value that may figure in a court's consideration of what public policy demands when a court is asked to consider whether the terms of a contract offend against public policy. The court pointed out that there is a supervisory power that the courts enjoy under the law of contract to ensure, and it pointed out also quite strikingly that to ensure freedom of contract, we must recognize we must not allow it to be used as a private mechanism that vacates fundamental public values. However, in the particular case, there was no complaint that the clause in question was to be struck as offensive to public policy. Good faith was not invoked for that particular purpose in the matter. Against that background, the court found that there was no interpretation of the subscription agreement that provided for the requirement of consent. The High Court had found that because Capitec had behaved in a contradictory way by holding out on occasions that its consent was required and then asserting on other occasions that it was not, justice required that the subscription agreement should be taken to require Capitec's consent. The SEA, however, noted that whatever view is taken of Capitec's conduct and its changing stances, it does not permit a court to impose an agreement that the parties did not make, whether in the cause of good faith or justice or any other abstract principle or virtue. The Supreme Court of Appeal remarked in closing that the ambitious efforts to use the concept of good faith to re-engineer the subscription agreement so as to require Capitec's consent and then to find Capitec wanting for failing to give its consent cannot prevail. The subscription agreement, properly interpreted, contained no such provision. Now, having said all of that, some comments from a practical perspective are the following. To avoid uncertainty, parties in South Africa and generally in common law jurisdictions that want to have an agreed standard of behavior during the performance of the contract will need to insert good faith as a particular provision. The parties could do so by either having good faith incorporated as a broad general standard to the contract as a whole and or to specific provisions. I think this will go some way to avoiding contractual and jurisprudential interpretation issues at a later stage. If we look at a dispute or arbitration setting, when establishing an argument centered around good faith, the task becomes slightly less difficult when the argument is based on an expressly recorded obligation. Where a broader general standard has been adopted by the parties, it will still be necessary to convince a tribunal how that standard is to be applied to a particular scenario. And where good faith is set to apply in specific instances, then too it would be necessary to demonstrate how it is that the other party is failing to act accordingly, for instance, unfairly or unreasonably. Where good faith has not been expressly recorded as an agreed obligation, I think it may still be possible to argue for its application. To do this, however, a litigant will rely on the jurisprudence mentioned a bit earlier on, particularly some of the constitutional court cases. It should be noted, however, that in addition to overcoming the hurdles I've mentioned just now for when there are express provisions of good faith, where there isn't such an express recordal, it will be necessary as a starting point to convince a tribunal that the standard applies as a matter of law in the particular circumstance. And immediate counter arguments that you could be faced with would be that of legal certainty, and also that the tribunal cannot make a contract for the parties.
Thank you, Mohammed. Claire, would these considerations differ if the arbitration was seated in London, or for that matter, other common law jurisdictions?
No, I think many of those same considerations would apply, and those practical considerations that Mohammed's just been describing are ones that I think would be very useful to bear in mind in the instance where you have an English law contract or an arbitration that's seated in London or another common law jurisdiction. I think with particular relevance to English law, I think if you find yourself advising or drafting on commercial contracts that are to be governed by English law, the key is to be mindful of whether or not the contract is or could be considered a relational contract. And referring back to the Yam Seng case that I mentioned earlier, you'll recall that there an implied duty of good faith was found because it was a relational contract. And that case set out a general description, a general definition of what is understood to be a relational contract. And generally, as I mentioned, these will be a long-term contract, one which requires a very high level of communication and cooperation between the parties. And kind of as a concrete example, a 25-year PFI contract has been held out as a paradigm example of a relational contract. And because, as we've seen, the English law may imply a duty of good faith into such contracts, to the extent that parties don't want that to be the case, then the practical way to exclude it, to exclude that possibility, similar to under South African law, is by an express provision ruling out such a term in the contract. By the same token, if the parties do want to make sure that they are obliged to negotiate or act in good faith together in the performance of a contract, then the practical way to achieve that is through an express provision, as in the absence of a relational contract where a provision might be implied, the court is going to be slow to imply a duty of good faith. Now, that said, the inclusion of an express obligation to act in good faith isn't always going to do the trick, particularly where there is or where there could be argued to be any uncertainty or vagueness about what that duty entails. And providing as much objective criteria by which the exercise of good faith can be measured will enable either the parties or the court to calculate the cost of damages that are likely to be suffered in the event of an alleged breach of good faith, and will give the clause a much better chance of being considered enforceable.
You mentioned that under the English law position, relational contracts, if the contract meets the requirements of a relational contract, then the duty of good faith may be implied, but that it is otherwise not included in the contractual relationships. But with this in mind, is it implicit in international arbitration agreements that the parties will act in good faith when conducting the arbitration, or does this also need to be expressly agreed? And would this position differ depending on how the underlying procedural law or the law of the seat might recognize the principles of good faith?
Thanks, Andrew. Yes, I think the answer is yes. Parties engaging in arbitration proceedings and their counsel are bound to do so in good faith. And as to whether or not that obligation arises implicitly or explicitly, well, often I think we'll find in international arbitration proceedings, it's an express one. And I'm thinking, for example, of certain institutional rules according to which arbitrations may be run, which provide expressly for the parties to act in good faith. And I think, one of the best examples of this is the LCIA rules, which are very commonly applied rules in common law arbitrations, English law arbitrations, often seated in London. And the LCIA rules in respect of the general conduct of an arbitration set out at Article 14.2 that at all times the party shall do everything necessary in good faith for the fair, efficient, and expeditious conduct of the arbitration. And likewise, under Article 32.2, the LCIA rules state that each of the parties shall act at all times in good faith, respecting the spirit of the arbitration agreement. So the articulation of that article suggests that the spirit of an arbitration agreement is one in which the parties will act in good faith. And another example of an express duty of good faith in the conduct of arbitration is, of course, in the IBA rules of the taking of evidence, which we're all very familiar with as they're so commonly adopted by parties for the conduct of their proceedings, particularly in respect of everybody's favorite aspect of arbitration, document production. Now, in the preamble of the 2020 IBA rules, it's expressly provided that the taking of evidence shall be conducted on the principles that each party shall act in good faith. And again, Article 8 of the rules goes on to state that if the arbitral tribunal determines that a party has failed to conduct itself in good faith, the arbitral tribunal may, in addition to any other measures available under the rules, take such failure into account in its assignment of the costs of the arbitration. So there we see an express obligation on the parties to act in good faith, and an indication that as and when they're found not to have done so, that could have fairly serious cost consequences. But in the absence of any express obligation on the parties to conduct their arbitration in good faith, there's also likely to be obligations on parties' counsel to act in good faith in accordance with their professional regulations. For example, solicitors in the UK have a solicitor's code of conduct, which obliges them to act in proceedings before tribunals in a way which is akin to good faith, not tampering with evidence, not wasting the court's time and the like, things that we all do as practitioners anyway. Sorry, things we don't do, I should say. And one final comment on this is that the arbitration agreement between the parties within a contract is, of course, a separate contract from the instrument in which it sits, and often under which the dispute itself arises. We're all familiar with this concept of the doctrine of separability. And there's been a lot of discussion over recent years as to the governing law of the arbitration agreement, that separate agreement, and the governing law of the contract in which it sits. And the French courts and the English courts have taken very different positions as to what the law of the arbitration agreement is or should be. And that was the series of cases, Kababji and Koot Food Group in the French courts, and the Enke and Chubb cases in the English courts. And the French courts and the English courts, as I say, took very different positions as to how, in the absence of a specified governing law of an arbitration agreement, how the governing law of that arbitration agreement should be determined. And given what we've discussed today, to the extent that the governing law of the arbitration agreement were deemed to be a civil law, for example, French or Spanish or UAE, where there is, a clear principle of good faith that applies, then obviously, and that sits within a contract which is an English law contract, which refers to the substantive provisions. That is something, of course, for us to consider. And so then, yes, in addition to any express obligations of good faith that might arise in the arbitral rules that are applicable to the proceedings, then there would also be a governing principle of good faith as expressed in the civil law system that then governs the arbitration clause itself.
Thank you, Claire. Mohammed, the AFSA international rules provide that all matters not expressly provided in the arbitration agreement, that for matters not expressly provided in the arbitration agreement, then AFSA, the court, the secretariat, the tribunal, and each of the parties shall act at all times in good faith, respecting the spirit of the arbitration agreement, and shall make every reasonable effort to ensure that any award is legally recognized and enforceable at the seat of the arbitration. So following on from what Claire said, there seems to be a encoded or expressly provided good faith provision. So assuming the arbitration is seated in South Africa and that the arbitration agreement is subject to South African law, how would this clause be impacted by South Africa's legal position as it relates to good faith?
That's an interesting question. Thanks, Andrew. If I could start off by just stating the obvious, due consideration should be given to that type of provision and its potential consequence. I believe that clause is Article 38.4 from the international rules, and it makes clear that it applies to all parties involved in the arbitration, and it also provides some guidance to parties on how to proceed when a matter is not expressly regulated by them in the arbitration agreement. I think the words "shall act at all times in good faith" suggests that good faith is a freestanding obligation, similar perhaps to some of our constitutional jurisprudence. This observation is indirectly supported by the fact that other arbitral institutions, such as the ICC, for instance, do not speak of good faith in the same context. If we look at Article 42 of the ICC rules, it provides that in all matters not expressly provided for in the rules, the court and the arbitral tribunal shall act in the spirit of the rules and shall make every effort to make sure that the award is enforceable at law. There's no direct reference to good faith. As to how as to what the South African position would be on the particular provision, given that the parties would have agreed to the AFSA rules and including Article 38.4, the obligation to act in good faith will likely be upheld by our courts. Having said that, and having regard to the Capitec judgment I mentioned earlier, it's unlikely that a court will allow the provision and the standard of good faith to be invoked for purposes beyond that which it was intended in Article 38.4, or where there is an express provision in the arbitration agreement which runs contrary to what is being raised on the basis of good faith. If I could just conclude by noting that in addition to being referred to in the AFSA international rules, good faith is incorporated into South Africa's international arbitration framework. For instance, Section 9 of the International Arbitration Act makes it clear that arbitrators and institutions who do not act in bad faith when discharging their functions will be granted immunity and avoid liability for their acts and omissions. Also, Section 6 of the Act stipulates that subject to its provisions, the model law will apply. Notably, the model law makes it clear in Article 2A that good faith is to be regarded when interpreting the model law and by extension the Act. Article 2.8 states emphatically, in fact, that in the interpretation of this law, regard is to be had to its international origin and to the need to promote uniformity in its application and the observance of good faith.
Thank you, and thank you both for those views. Very interesting, and very interesting to see how it's dealt with across different jurisdictions. I think the key takeaways from our discussion this morning are that good faith as a legal concept has different standings, has a different standing depending on which jurisdiction you may find yourself in. So when conducting international arbitrations, consideration should be given firstly to the governing law of the contract, the substantive law of the contract, and in circumstances where it may differ, the governing law in the arbitration agreement. I think what Claire said is also important, that in circumstances where the governing law is not mentioned in the arbitration agreement, then the position is different within English and French laws. My personal views are that South Africa would more likely align with the English law position on that and make it the law of the seat. That would be applicable. So there may be significant differences as to how good faith as a principle is dealt with depending on the institution that or the jurisdiction you might find yourself in. So when engaged in arbitration proceedings, parties who are party to arbitration proceedings and their counsel are bound to do so, I think, in good faith, taking into account all of the considerations that both you, Claire, and Mohammed have mentioned, in order to give effect to the arbitration agreement. And if it's not an express obligation, it may very well be likely implied within the broader context of the arbitration agreement itself. Before we wrap up for the morning, we did say that we would have some time for some questions. I can't see if there have been any questions placed in the chat, so I will rely on somebody else to maybe let me know if there have been. Otherwise, I will open it up to the floor for 2 minutes to see if anyone would like to answer or ask any questions. We'll answer them insofar as we can. Otherwise, I think that would bring the morning's proceedings to an end, and we would thank everyone for joining us, and for Michael and AFSA for hosting us. And if there are any further questions, please do let us know. And if something pops into your mind after we've logged off here, then again, please feel free to reach out to us.
Yes, thank you so much. Our IT people are just looking at the questions that have come in, and we'll see if we can get them to you now, or whether we'll have to send it to you thereafter. But it's been a truly fascinating discussion, and it's one that without your expertise and without your bringing it to our attention, may well not have been appreciated as so important a topic to bear in mind. And can I say that in terms of our policy, this webinar will be available and accessible on the AFSA websites, and I would very much anticipate that in the course of training in international arbitration and the like, we will find that presenters do refer the students to this particular webinar for its very great value in an understanding of how the jurisdictions can interact in surprising and unexpected ways. So thank you again, Claire and Mohammed and Andrew, for illuminating a topic which is the case law that I referred you to indicated had not been well exposed in the English courts until now. Thank you, Brian. If you can let us know whether there are any questions you're able to pass on to the webinar straight away.
Michael, no, there aren't any participants in the chat or the Q&A. So
very well. When and if they get round to asking us the questions, we'll pass them on to the participants, and I hope we'll get answers which we can also include in our website. Thank you again. Thanks very much for joining us, and we look forward to the next episode in this ongoing series of The Cutting Edge. Thank you and good morning.
Thank you, everybody.
Thanks all. Bye.
Thank you.